We'll now take up Part 3 of Interim Charge Number 7, which directs us to monitor the implementation of initiatives aimed at improving the State Board of Dental Examiners' ability to protect public safety, including strengthening the board's authority and enforcement powers, improving complaint review and resolution processes, and increasing staffing to improve the board's ability to respond to complaints and potential fraud activity. The charges also directs us to determine whether there are additional changes necessary to ensure that the board is able to regulate the practice of dentistry and ensure public safety. The chair calls Julie Hildebrand, Executive Director, Texas State Board of Dental Examiners.
Hi. Yes, I'm Julie Hildebrand. I'm Executive Director with the Texas State Board of Dental Examiners. I also have with me Lisa Jones. She's our Director of Enforcement, and Nicia Deal is our General Counsel, pretty much brand new, about a week. So she's...
Before you begin,
sure.
We heard just terrible testimony in Senator Nelson's committee last session in reference to the maltreatment, mistreatment, overtreatment, and really assault of our pediatric Medicaid population. And House Bill 3201 was an attempt to address some of those areas of deficiency that might prevent and or discourage individuals or entities from providing dentistry care in that manner. And that's my focus today, is where I would like you to concentrate on where we are as a state in making sure that the practice of dentistry is being properly regulated, and those that are potentially abusing the system financially and certainly abusing patients are being taken care of.
Yeah.
So please go ahead.
Okay. So you do have a presentation for you, and what I tried to do was just go through each section of the bill and kind of give you a summary of where we are right now. Then I also attached all of the rules, just for your reference, that had to do with the bill that were implemented.
Can you give me an overarching view of where we are in reference to 3201 and the protection of patients in Texas?
Yeah, I think the biggest way to answer that is that previously we had so many different, we had shortages in FTEs and money. We had processes that weren't working. And so just our basic infrastructure was not strong enough. And so improving the general infrastructure has made us to where we can address all cases in a much better way than we have in the past. As far as the specific cases with Medicaid patients, the way that'll work is if there's a complaint that is received through Medicaid that they see through their fraud detection, and that also involves a professional issue, so patient abuse where it's the standard of care, then they'll refer those cases to us, and then we're able to investigate and then move forward on those cases.
You said professional, also a professional issue. Does that imply that your agency, the State Board of Dental Examiners, does not have enforcement action in reference to corporate entities acting in a contractual or managerial position?
Right. As far as
does it have the ability to regulate those entities?
Right. We do not have ability to regulate them. What we do have the ability to do, our law says that if you own a practice or maintain or operate a practice, or if you influence a dentist's professional judgment, then that would be considered to be practicing dentistry. And so we do have the ability, if we see that, to then go and do a cease and desist against anybody who's practicing dentistry without a license. What we do also have the ability to do is to regulate the dentist, obviously. So and our law says that if you're the owner of a practice, which would be a dentist, and there are improper things that are, there's violations of the law within your practice, ultimately you as the owner are responsible for those actions. So, for example, if a dentist comes into the office for a complaint as a respondent, and say the allegation is that they are doing improper marketing through Medicaid, and so they're going out, the stories that we heard of the going out in buses and collecting patients to bring them back. Under our law, that would be against the law, and then also under Medicaid, that would be against the law. if the respondent dentist were to say, well, that wasn't me, that was somebody, the non-dentist that I'm partnering with, we would still be able to say under our law, well, as the dentist, as the owner, you are responsible for
But you're
the
telling me
actions.
today that you're not able to go and prosecute or investigate the other entity.
Correct.
The State Board
Correct.
of Dental Examiners cannot do that.
Correct. That is how the law currently stands. We can do a cease and desist order if we can prove that they are practicing dentistry. But we cannot take action against them for specific actions that they are engaging in that would be a violation of the Dental Practice Act.
Okay. Do you believe there is a corporate practice of dentistry occurring in the state?
Yes, I do. I think there's.
You do?
Yes.
But yet you don't have the enforcement powers through your general Texas Dental Act to enforce that if there is the corporate practice of dentistry?
Right, correct. We can do the cease and desist orders, but when you have...
But you cannot prosecute for...
Right. If you had that example that I gave where, say, the non-dentist is in charge of the marketing, the advertising, the bank accounts... The administration of the maintenance and operation of the practice, if there's something that they do that is an advertising violation, for example, I cannot go against the non-dentist and take any action, but I can against the dentist. And that's our only option right now. And that's what, with rules that you've seen that have been proposed recently, that's been the goal, is to make it clear to the dentist, right now what we can do is take action against you, and that is what we will have to do. Yes.
Even though they might be influenced or enticed.
Or committed into a contractual relationship with a non-dentist. Because that's some examples we've seen is where a dentist is in a contractual relationship with a non-dentist. That relationship goes south for whatever reason, and the dentist is having troubles even getting their records back from the non-dentist. And that is a big concern because then the dentist can't see their patients.
The non-dentist has control of the records and will not release the records to the dentist that provided that care.
Yes, that's correct.
You know, I'm hearing lots of different, my memory must be failing me in reference to the testimony of the dental board to our committee, and even before I got on the committee, in reference to whether or not y'all were able to properly regulate dentists. Of course you can, but all their entities that might be acting in a supervisory or managerial or employment type relationship with the dentist. It's confusing, but also terribly troubling that we can have entities in our state that are essentially, you're telling me we have the corporate practice of dentistry, or we're seeing that, but yet we can't really enforce it.
Correct.
Or regulate it.
And there are, to be fair, there are dental service organizations where the dentist hires somebody to perform certain services, just like you would hire a bookkeeper, you would hire an attorney to your legal services, but they maintain full control over those services. So they're still responsible for, so again, back to the advertising example, you're going to come up and tell me a great way to do advertising, but I'm going to sign off on it because it's my license on the line. So there is situations where that is properly occurring, that the dentist does have somebody else do all of their business management type things, but they are still in full control of the actions that are being done by the non-dentist. Another good example is the insurance billing. A lot of times what we'll see even for Medicaid or private insurance, if there's a mistake, quote, in the insurance billing, the dentist's response will often be, oh, well, I'm not in charge of the billing. That's the person that I contract with, the non-dentist that I contract with. They handle the billing. So I didn't even know that was being done incorrectly. And so, again, what's so important with these new rules is to make clear to dentists that you can't do that. You have to know what's being billed for and what your responsibilities are.
Sarah Nelson, any questions?
Yeah, oh, yes. And Mr. Chairman, I know you know that I filed legislation last session to address are concerns of what you very, I think, appropriately call the corporate practice of dentistry. And you mentioned the rules, and I guess my question is a little bit more information about the rules that you said you're going to have a hearing on in October?
Yes, they've been proposed. They were proposed at the board's last board meeting that was on Friday. We had one committee meeting that was where we took public comment. And then, so we are now, and we did receive some comments in writing also before the board meeting. At the board meeting, they did choose to go ahead and propose the rule, so we could invite as many comments from as many people as possible. And then, yes, we'll have a committee meeting with public hearing. We're expecting to do that early October. We wanted to give people enough time to get their comments cleaned up and ready to present. And then it'll be up for discussion again at the board's November board meeting. So it could be voted on for adoption there. It could be re-proposed with changes that, were discovered during the public hearing and subsequent redrafts of the rule. So it could be re-proposed or adopted, or they could decide to leave the current rule as is. But that's where we currently are right now, is accepting comments.
So what you're telling me is all that would be prior to the next legislative session?
That's our hope, is to get, that's why we wanted to start moving at this point.
And do you think that you will be able to, correct some of the things that need to be correcting through rule, or do you think that it's going to take legislation?
I think that what I've been talking about with the dentist being the one to be held responsible,
right,
we can correct that. We can make it clear that dentist, you can't use it's the other guy excuse anymore.
Good.
What we won't be able to correct, or I guess what we can also correct, is that if somebody is acting as an owner or maintaining or operating the practice, or if they're having an improper influence when they're a non-dentist, we can correct that by doing a cease and desist order, which means they just can't practice at all. What we won't be able to correct without legislative change is some sort of option where you allow a non-dentist to have more influence, but that you regulate how they are affecting the patient. So that is not an option at this point without regulation, without new law.
Thank you, Mr. Chairman.
Senator Zaffarini.
Thank you, Mr. Chairman. Looking at what we have in our notebooks, there's a lot of information about the board itself, a list of the technical rules changes, and certainly a whole excerpt from the Texas Administrative Code, and we appreciate that. But what specifically can you tell us about our charge, which is to monitor the implementation of House Bill 3201? What have you done about the review and resolution processes, the authority and enforcement powers, and how have you used the staff increases?
Yes, going through each of those, because there were several sections that were in House Bill 3201. As far as the first one, which has to do with surcharges, we've been collecting a surcharge. So that's the $55 surcharge, and we have been collecting that. We did for the investigative files, that's Section 2, and that just states that the investigative files are confidential, but we do have to give specific allegations.
Right, and we have that list. That's why I said we have the technical rules changes. But what have you done in terms of these other areas, for example, the authority and enforcement powers? How have you changed them other than just telling us you changed these rules?
Right. Well, with these changes and with the new employees, what we have been able to do, the biggest change I would say would be the dental review panel. So previously the way that it worked was board members we have 8 board members that are dentists, the rest of them are non-dentists. They were charged with reviewing every single standard of care complaint that came in. And we would have 2 of the board member dentists review those. And because they were not being paid, and because they have their own practices, and because they were not specialists in every case that they were reviewing, in all honesty, nothing against our board members, but our reviews were not very helpful. So the dental review panel has made the biggest difference. It has now to where we also have a dental director has come on staff, and that's been very helpful too. So when a case comes in, a complaint comes in, If it's standard of care related, it goes to the dental director. The dental director reviews the case during the preliminary inquiry period and determines whether there's a standard of care issue, in a fact issue. If there is, then that'll go to the dental review panel. 2 of 3 people have to, these are experts, they're paid, that's what some of the funding went towards. They're reviewing those cases. The biggest difference as far as actual result, rather than just true compliance with the bill, is that we're getting much better expert reports on cases that we're working. The attorneys that we have are literally just dancing. They're so excited with actually having an expert report in order to prosecute a case. In the past, you would see a lot of our cases settling because we just didn't have strong enough evidence to go forward. Now we have the expert reports, we can move forward, we can take action. And so I think there will be a period of time where everybody will be adjusting, and a lot of the cases will be litigated, but eventually I think we'll get to the point that they're not all litigated. They'll see there is 2 expert reports saying that they fell below the standard of care, and there will end up being more settlements. So the preliminary inquiry has been a big impact because that also gives us the opportunity to review those cases within the first 60 days. Previously, what was happening was that examples we looked at the same time period from 2013, January 1st to August in 2013 on a standard of care case. We only closed, of those that were received, we only closed 6. This year, we've now closed, I believe, 86 within that same time period. So it really has, this is a very different agency than we were a year ago. And it has been because of the procedural changes, the increase in FTEs. For example, with attorneys, we went from 3 attorneys that were truly on staff working to now 7 attorneys, and that's made a huge difference. Same with investigators. We've increased the investigators. We also have a new position that we didn't have before, we call them inspectors, but what they're doing is collecting records. So something that normally would go out to the field staff and they would have to do an office visit to collect the records, we've now got people that work here in Austin that just send letters to collect the records. We give them their 30 days. They have to get them back. That's one part as far as something that would help as far as future legislation is right now they have 30 days to respond when we request records. And we only have a 60-day period to begin with to review the whole case to determine whether to move forward or not. And other agencies that have this same type of setup, their records have to be due within 15 days, I believe. So that would be a big help to us it might still be that when a patient requests that it would be 30 days, but if the state board requests it, it needs to be 15 days rather than if we're still going to get it all done within 60.
But generally, your testimony is that House Bill 3201 and its effects have been positive, that the board has been strengthened and they can preclude fraud in the future?
The effect on the fraud specifically, I think, is more to the idea because we don't have, as far as Medicaid fraud, we don't administer that. So we don't have a direct effect on fraud in that sense. But I think how 3201 has helped us the most is it has given us an infrastructure base that we didn't have before. And so we're able to prosecute all of our cases in a more efficient and in a higher quality way, which would include your fraud cases. But House Bill 3201 didn't specifically target fraud cases, but you are seeing improvements. And I guess we have had this discussion that you did see when you have your dental review panel looking at the cases. Again, when you had a board member glancing over a case, they're not really looking at every single detail in there. We are noticing that when it's reviewed by 2 dental review panel members, they're actually looking at it, not just what was complained about, but the whole patient case, and they're seeing more fraud is coming up.
But in
Whereas-
strengthening your ability to respond to the complaints, and
Yes.
strengthening the board itself, hasn't that in and of itself
Yes,
served
would
as a
have to-
deterrent to reduce fraud?
Yes, and I think that's correct, and that's, yeah.
Thank you. Thank you, Mr. Chair.
Thank you. I'm getting the sense that the dental board has, through 3201, improved its ability to investigate professional misconduct, standards of care issues, and maybe secondarily deterred other avenues that and wrongdoing that was going on, specifically the inappropriate relationships and incentivization of dentists by DSOs or by other dentists that were employing those dentists as a quasi-corporate structure. But going back to our original concern, my original concern last session was protecting Texans,
Right.
and regulating the entirety of the practice of dentistry, including those that have control over dentists.
Right.
But you're telling me, again, if I heard you correctly, you have no authority to regulate or intervene in entities, whether they're corporate entities or non-corporate entities, that might have undue influence on dentists and their professional judgment and independent practice of dentistry.
Correct. If they're a non-dentist, all that I can do is to tell them to stop practicing dentistry.
Right. That's troubling, because the worst cases that we saw, Madam Chair, were the ones that were dentists that were acting as a corporation. They weren't even practicing dentistry. They were just acting as a corporation, hiring other dentists, setting up dental practices, primarily in the Metroplex, I believe, and incentivizing dentists to push out cases and push out revenue and push out procedures.
Yeah.
And you can come after those dentists that are doing that.
Yes.
But the actual reason they were doing it, one of the reasons, of course, is the undue influence and enticement and inducement and incentivization by those corporate structures, are in this case the non-corporate structure that was actually a PA or an individual dentist but not practicing dentistry.
Right, and that's to add another tool that we do have, and that's what we're doing with 108.70, is saying by controlling the dentist, we can say what types of contracts they can enter into and what that
Yes.
contract should not look like.
Maybe we should apply it a different way as well. But I'm sorry to get off the soapbox there. Other questions, senators? Soapbox. Do you have any organized, other than going, I piecemeal
Yeah,
by piecemeal
you
on
have-
3201? We can do that, members, but
Yeah. But no, the big picture is that, yes, it has changed. It has given us an infrastructure we didn't have before, and it's given us the ability to actually get through cases and have do it in a high-quality way. And we just didn't have that ability before. So we're all very happy to be working where we work now.
And you've been executive director for how long?
For a year.
A year.
I was with Pharmacy Board for 13 years, and then came over to dental as the general counsel for the year before this, and then have been in this role for a year.
3201
So, yeah, it's
requires dentists to state whether or not they have a contractual relationship with a corporate entity. Is that correct? In
Yes,
their
we're-
renewal notice?
Yes, and
But
we're
it does not
collecting that.
require the corporate entity to register or disclose how many dentists they supervise or have contracts with, for instance.
Correct. We can ask them a certain question, and to get that exactly right, I'm going to look. It says, if requested by the board, a dental service organization shall provide to the board the address of the locations where the organization provides dental services in this state, and the name of each dentist providing dental services at each location. So we can ask that question.
What's the board done in reference to that? Have you all collected from DSOs the addresses of locations where the organization provides dental services in the state and the name of each dentist providing dental services at each location?
What we're doing right now is from September 1st, 2013 through August 31st, 2014, we've been collecting from the dentists because, again, a year ago when the question was asked, who are the DSOs, our answer was, I don't know. So what we've been doing is for a year, we've been asking dentists, who do you contract with, non-dentists? Do you own a DSO? So we've been asking all the questions to the dentists, And we've now got that raw data, and it's interesting because I think most dentists wanting to comply have actually over-complied. So we've got a whole bunch of names that probably aren't DSOs. I've got CPAs, I've got Care Credit, I've got all the insurance companies. So now what we're doing is culling through that and getting to our DSO list, and then it'll be most likely start in early September to start sending out letters to the DSOs and asking this question.
But even if you had the accurate data, your testimony is you couldn't actually act on that data if you thought there was undue influence by the entity, whether it's a corporate or non-corporate entity, on that dentist. You could only act on the dentist.
I could act on the dentist, and I could send a cease and desist order.
Right. A cease and desist order.
Yes.
That's very troubling. We're going to be visiting this some more, I'm sure, this next session. Members, any other questions? I'm not going to harp on this too much longer, but I've gotten a little clearer. And your new team here, is this the new general counsel?
Yes, yes.
And
This
she's
is our
brand new?
Nicaea deal. Yes, she was with the dental board previously, left, and then went to the medical board. She
Great.
was with them, got lots of litigation experience, which has been very helpful with her
We'll be
coming
talking,
back.
I think my staff has reached out to you a couple of times, and we look forward to hearing your answers about some of the concerns that we raised, and we'll be meeting with you in reference to this issue and other issues in the near future. Thank you.
Sounds good.
Excuse me, Mr. Chairman, I think she's getting off way too light. She ought to at least have to introduce herself.
My name's Nicaea Deal. I'm happy to be here.
Welcome.
And I'm sorry, who's in the middle here? So we say your
I'm
name.
Lisa Jones. I'm the Director of Enforcement.
Director of Enforcement.
I've been with the board a little over 11 years, almost 12.
Okay, so you have some seniority and tenure there.
Yeah, I think there's only 2 other people with the board that have a couple more months than I do. Yeah.
And a wealth of information.
A wealth of information. Okay, very good. Thank you.
Thank you.